Good evening, everyone, and welcome to part one of the 30th Annual Family Law Update, presented by the three amigos, Commissioner Keith M. Clemens, Commissioner James E. Endman, and Judge Robert A. Schnider. Part two will be 1 week from today, Wednesday, February 3rd at 5 p.m. Please make sure to register and join us then.
We want to take a minute to remind everyone about a couple of other upcoming programs. On Monday, February 1st at 12:30 p.m., we are co-sponsoring Toxicology Pearls for Attorneys with the litigation section. This program, moderated by Rudy Lehrer, features speaker Allison A. Moeller, a board-certified toxicologist and a pharmacist. She'll give a broad overview of what attorneys need to know about the effects of alcohol, as well as common street and prescription drugs on the body, interpreting drug screens, and the connection between drug levels and impairment. Also, please mark your calendars for our annual Meet the Judges Night, which will be held virtually on February 17th at 6 p.m. with a very cool optional mixology session at 5:30.
The Family Law section in all of its programs is sponsored by SoberLink, White Zuckerman, Warsawski, Luna Hunt, LLP, Our Family Wizard. Event sponsors for the 30th Annual Three Amigos and Family Law Update are Signature Resolution, Schnider, LLP, Ron J. Infuso, CPA, Feinberg, Mindel, Brandt & Klein, LLP, Californian Estates, and ARC, Alternative Resolution Centers.
Right. Now to introduce our wonderful speakers, starting with Commissioner Clemens. He specializes in family law and has served as a private judge, judge pro tem, mediator, arbitrator, discovery referee, CCP Section 638 and 639 referee, special master, family law facilitator, and case manager for the past 2 decades. He served on the Los Angeles Superior Court from 1991 to 1996, where he presided over family law direct calendar courts, family law trials, mandatory settlement conferences, OSC hearings, law in motion hearings, ex parte matters, domestic violence cases, and mandatory and voluntary settlement conferences.
Next, we have Commissioner James Endman, retired, was assigned to the Los Angeles Superior Court's Family Law Department for 25 years and is best known for the In re Marriage of Keech case, which resulted in the concept of the Keech Declaration. Prior to his service on the bench, he practiced family law for almost 2 decades. He's well regarded by the family law bar. Commissioner Endman has a formal yet comforting manner that is well suited to resolving emotionally charged disputes.
And finally, Judge Robert Schnider retired in 2008 after spending nearly 3 decades assigned to the court's family law department in the Central District. One of the state's most experienced family law jurists, Judge Schnider regularly made rulings in high-profile custody, paternity, and other disputes involving celebrities such as Michael Jackson, David Hasselhoff, Kim Basinger and Alec Baldwin, and Anna Nicole Smith. He has handled thousands of settlement conferences during the course of his career.
Attendees should have received a link to the materials in the 1-hour reminder email, and the BHBA will also post a link to the materials in the chat. MCLE certificates will follow by email in about 24 hours. And without further ado, we'll pass it off to the amigos. Thanks.
Thank you very much, Ron. We're going to start right in with Locke versus Locke at page 1 of your materials. Father was a lawyer who fell on hard times after his disbarment. Arrearages and child and spousal support mounted up to over $160,000. Father qualified for Social Security Disability, that's SSDI, and the CSSD began intercepting some of those funds. In Father's appeal of the trial court orders setting arrearages, the court ruled on a variety of issues. First, during one period of time, Father was under an order to pay $49 a month on the arrears as a probation condition following a contempt finding. The department took more than $49 per month. That was okay, said the Court of Appeal. The probation condition is not a modification of the underlying order on arrearages. It was just a minimum payment that kept Dad out of jail. The next issue was, what is the limit the department can take from SSDI? The court first notes the general limitation that limits wage assignments for arrears without a specific payment order from a court to only 25% of the current support order, or a maximum of 50% of the disposable earnings of the payor when combined with the current support order. But it gets more complex with SSDI because Family Code section 5246 sub D sub 3, which limits withholding from SSDI to 5% of the benefit. And please note, we aren't talking about SSI here, and that's a needs-based payment, which is fully exempt. But the 5% limitation only applies when the recipient has sellable assets of less than $2,000. And it's the obligor who has the burden of proving that. Well, says Father, I did prove it. Look at my FL 150. But, says the court, you left a blank on the line for stocks, bonds, etc. And we can't infer a blank means zero. So you didn't prove it, and you lose the 5% limitation. There is a Court of Appeal case that would seem to support Father in remarriage of Hopkins, but this court thinks they got it wrong, and they declined to follow it. Next issue involves the derivative Social Security benefit paid for Father's minor children because Father was receiving disability. Family Code section 4504 says these payments get credited toward the support obligation. The amount of the benefit fully satisfied the current support order here, and the balance was applied to the arrearages. But Father says the excess should be first applied to the court order arrearage payment of $375 per month. Court of Appeal says no. The trial court properly balanced Father's need for funds and the benefit to the children from getting both the excess derivative benefit and the $375 per month directly from Father's benefit to reduce that $160,000 arrears. Finally, the department admits that at a certain time, it overcollected from Father's disability income, and under the rules, Father asked for reimbursement of that amount. But again, the Court of Appeal says no, essentially based on the large arrearages owed. This is a complex case packed with useful explication of Social Security and family law rules and should be closely studied if you have a case with these issues. Jim.
Our next case is marriage of Hine. We are dealing here with the effect of Internal Revenue Code section 179 when calculating income available for child support. So generally under 179, you can deduct from your taxes the entire cost for the purchase of tangible personal property that was acquired to be used in the active business or trade. There's a maximum deduction of $2 million, and also it cannot exceed the income of the business. In effect, what you're doing is you don't depreciate the asset over the useful life, but you're actually immediately taking the cost off. Well, looking back at Asfaw versus Walderman at 207, 147 Calap 4th, page 1407, the appellate court disallowed depreciation as it related only to real property. And they made it clear in Asfaw that they were limiting their decision to real property. So here the question is, are we applying the same concept to personal property under 4059 of the Family Code? Only business expenditures required to operate the business can be used to deduct from the gross income for purposes of child support, and not phantom income, if I can use that phrase, can be used as deductions. Thus, applying ASFA, whether expensed or under IRC 179 or depreciated, that you're not going to be allowed to deduct the depreciation or the expense with regard to personal property as well as to real property. So what do you do when you're purchasing assets for the business? That answer is in DeLuca, which I'll be talking about a little later, so you'll have to wait for that answer. Final point in Hein, there is not a presumption that one's personal or business income taxes and returns are correct. The party who prepared them or ran the business has the best evidence available to support the deduction. They have the burden of proof to apply, show that the tax returns are correct. Back to you, Bob.
Thank you. In remarriage of Sawyer is at page 4 of your materials. After a Minnesota court makes a child support order, dad allegedly fails to make full payment. In 2001, the Minnesota court finds a little over $89,000 in arrears. In 2005, the Minnesota order is registered in California under UIFSA. Dad gets the required notice that he has effectively 25 days to object, but he files nothing. Between 2007 and 2009, he does try to contest the underlying order in Minnesota, but he loses. In 2013, DCSS files a contempt, and dad responds by asking for an accounting with credits plus termination of collection efforts. Denied. Finally, in 2018, a new Minnesota order is registered with interest pushing the total to just under $140,000. Dad objects to this one, and while the trial court denies his request to vacate everything, he does get Jackson credits for about $28,000, leaving around $60,000 of the original order to be enforced. Both father and the department appeal, but only one side walks away happy, the department. While the facts underlying the Jackson credits are true, the children did live with dad for periods, he blew his opportunity to raise the issue when he failed to object to the original registration. Family Code section 5700.601 says, after you get the notice, you have 20 days, extended by 5 if mailed, to object, and if you don't, the order is confirmed. Section 5700.608 says, confirmation precludes any further contest of the order on any ground that could have been raised at the time. But we're a court of equity, says dad. The trial court exercised its equitable power. Court of Appeal replies, the court can't use equitable power to ignore express statutory requirements. Dad's appeal, based on lack of personal jurisdiction and denial of a chance to present additional evidence, also fails on the same ground it's too late. And by the way, Court of Appeal adds, of course, Minnesota had personal jurisdiction. Your divorce was there, and you had an attorney represent you at the 2001 hearing. Jim.
Next case is County of San Diego versus PB. Here we are confronted with a fact pattern that unfortunately is not that uncommon. Well, father is initially awarded joint physical custody of the minor child, and child support is based on 50%. The child has significant psychological attachments to mother and assimilates her dislike to father. Child and father are then awarded reunification therapy, and this involves a 29% visitation. The reunification fails and no visitation thereafter takes place. Well, the code allows only limited circumstances for deviation from the actual timeshare. Generally, that would be when the child is not with either parent or when the child is away at a boarding school. The trial court nevertheless allowed the 29% factor because of mother's interference with visitation. However, the law is well established that the duty of child support is unaffected by the interference with visitation. There have been many cases on this point in the past. The appellate court takes the time to point out that the trial court was rightfully concerned with mother's interference, but the proper approach should have been either a contempt or a custody change. Child support cannot be used to penalize the custodial parent in order to induce some cooperation. The child support has to be based on the actual amount, 0. A quick note, if non-visitation, by the way, under a new renewal of a statute that just got renewed, if a party is incarcerated for more than 90 days, then 4700.5 has been reinstated, but it's in effect only until January 1st, 2023. And during that time of incarceration, child support is suspended. Bob?
Okay, In-Ray KT is at page 7 of your materials. This dependency court case is most interesting as it's a reversal in an area where a trial court really has a lot of discretion. At the disposition hearing, the court receives evidence that dad has a long criminal history, including drug offenses, battery, DV, and that he has not cared for a baby in many years. But also they get information that the child was doing well with him, was healthy, was comfortable with him, he nurtured her properly, and he met her needs, and there were no safety concerns. So the child was placed with him, but dad was also ordered to take a parenting class. He appeals just that portion of the order, reversed as an abuse of discretion. And here's the line you want to cut and paste in a brief if you have the issue. Quote, criminal history, standing alone, has no bearing on parenting abilities, close quote. Since the evidence showed he was doing a very good job caring for an infant, the requirement of a class to tell him how to do it went too far and was reversed. Jim.
Okay, the next case is In-Ray JA. When the child was born, the mother tested positive for marijuana. Mother testified that she had researched the issue, and her research indicated it was safer to take marijuana than to use pills for her pain and swelling. The DCFS worker testified, however, that mother does not understand the risk she put the fetus to. The appellate court indicated the DFS position was pure speculation. DFS presented no evidence to counter mother's contention. While this is a Welfare and Institution Code case number 300 requiring substantial risk and harm to the child, we in family law should take note. Well, unless the judge hearing your case is old and crotchety and maybe wearing a red baseball cap, you must prove substantial marijuana abuse, but also how it is affecting the parenting of the child. Keith?
The next case is In Re Austin J at page 11 of your materials. In re Austin J addresses whether a state that had previously issued dependency court orders over minor children, but had returned the children to their mother, still has continuing exclusive jurisdiction when the mother moves with the children from North Carolina to California. Our mom, in this case, had 7 children by 2 fathers. North Carolina Child Protective Services took custody of all the children, and the North Carolina courts made the children dependents of the North Carolina court there. But the officials eventually returned the 7 children to mom, and the North Carolina Dependency Court case ended. Now, North Carolina Child Protective Services was ordered to investigate new allegations against mom and, if necessary, file a new dependency case. But North Carolina Child Protective Services did nothing because mom decamped with all 7 children to California in 2018. More than 6 months after mom arrived in California, Los Angeles County Department of Child and Family Services investigated mom and then moved to take custody of mom's children and filed a petition under Welfare and Institutions Code Section 300 to make them dependents of the California Juvenile Court. The Juvenile Court found California had jurisdiction under the UCC-JEA since the children lived in California for more than the 6 preceding months, and there were no current custody orders from North Carolina. The court made the children dependents and had them placed in foster care with services to mom and the father of the 3 children. Mom appealed, claiming California couldn't do any of this because North Carolina had exclusive jurisdiction over the children pursuant to the UCC-JEA. Mom appeals, but the Court of Appeal affirms as to the 4 children by the father not even in the picture, reversed as to the children whose father was in the picture, because by the time the Court of Appeal sees this case, the kids have been returned again to mom and their father. The Court of Appeal found that once North Carolina returned the children to mom's custody and ended its first dependency case, then even though North Carolina was thinking about initiating another dependency case but didn't do so because mom left the state fast enough, once the kids were in California for 6 months, California became their home state. California was entitled to exercise UCC-JEA jurisdiction. In short, an intention to open a dependency case doesn't give North Carolina continuing exclusive jurisdiction over the children just because they had exercised such jurisdiction in the past. They've lost it. Family Code Section 4323, which deals with the continuing exclusive jurisdiction, did not prevent California from exercising jurisdiction over the children just because North Carolina had once done something. Bob?
Aubrey T is at page 12 of your materials. I'll skip the very interesting procedural history of this case that includes stops in family court, juvenile court, and probate court, and focus instead on the ruling that gets overturned by the Court of Appeal. The trial court terminates dad's parental rights based on abandonment as sanctioned in Family Code Section 7822. One definition of abandonment is leaving the child with third parties for 6 months or the other parent for a year without communication or without financial support with an intent to abandon. And if the court finds the non-support or communication, then there's a presumption of the intent to abandon. Here, the trial court finds the child live with maternal grandparents for a year with no financial support from dad. Trial court says that establishes the presumption of intent to abandon, and dad didn't overcome the presumption. Slam dunk for the trial court, right? Well, of course not, as the trial court misunderstood the nature of the presumption. This is not a presumption that affects the burden of proof. Rather, it's a presumption that affects the burden of producing evidence. Once the person laboring under the burden of that kind of presumption produces some element to rebut it, the presumption goes away, and the burden of proof shifts back to the side that proffers the claim. Here the claim is dad intended to abandon, and that must be proved by clear and convincing evidence. Dad did make a variety of attempts to be involved with the child, so the proof fell short of the required burden, and the trial court gets reversed. Jim.
Our next case is Monasce versus Taglieri. And this, the US Supreme Court is dealing with the Hague Convention on the civil aspects of child abduction. As a general rule, the Hague Convention requires that when a child is wrongfully removed from his or her country of habitual residence, ordinarily the child must be returned to that country. The late Justice Ginsburg writes the majority opinion and notes that there is no definition for habitual residence under the convention. At least until the mother fled Italy for Ohio, the parties had a shared interest and intent to live in Italy, but they never had any verbal agreement to that effect. Based on the district court ordered, the child was ordered to return to Italy. Contrary to mother's argument, there is no requirement that there be an actual agreement. Where the child's habitual residence, that is a fact-driven factor according to the unique circumstances of each case. First, acclimation of the child is an important factor for the trial court to consider. Second, for older children, the intention and circumstances of the caregiving parents are very relevant. Third, for younger children, an actual agreement is not dispositive, but the facts where the child lived can help the trier of fact to determine what is habitual. Another consideration in a Hague case is whether there is domestic violence. The convention itself in section 13, subdivision B, provides a child should not be returned to their habitual residence where it would expose the child to grave risk or physical or emotional harm, or otherwise place the child in an intolerable situation. Here, Monasce alleged domestic violence, but she offered no proof. Just saying there is fraud in the election doesn't make it so. Where's the proof? In this case, the child must be returned to Italy.
The next case is Castro versus Renteria at page 16 of your materials. This is a Ninth Circuit Hague Convention case. Today's lesson is a delay in filing a Hague petition to return a child can be fatal. The child in this case is not named, so I'll call her Child. She was born in Las Vegas, but taken to Mexico by her parents who did not live together. The child lived mostly with her maternal grandmother in Mexico. Dad was imprisoned in Mexico for drug dealing. When he was released from prison in 2016, he shared custody of the child informally with the maternal grandmother. But in 2017, Dad and Carmen, who was the child's half-sister, sought legal and physical custody of the child and obtained a Jalisco court order for such custody. The court in Jalisco gave a couple of weeks of temporary custody of the child to grandma, but there was certainly no court authorization for grandma to take the child to the United States. But that's exactly what grandma did, taking the child to Las Vegas and telling Dad and Carmen that they would remain in Las Vegas indefinitely. On August 30th, 2017, the Jalisco court ruled that grandma had no right to take the child to the United States. Over a year later, September 7th, 2018, because Dad was back in jail in Mexico, half-sister Carmen files a petition in the Nevada U.S. District Court, seeking the return of the child to Mexico pursuant to the Hague Convention on the Civil Aspects of International Child Abduction. The district court that found that indeed grandma's removal of the child from Mexico to the United States was wrongful, but because Carmen didn't file her petition under the Hague Convention until more than a year after the wrongful removal of the child from her habitual residence, the court had discretion as to whether it would order the child's return to Mexico. The district court found that the child, who was age 9, had acclimated to living in Las Vegas, was enrolled in school, was doing well, had quickly learned English and made friends. She saw her extended family members who also lived in Las Vegas, and the child, who was very bonded to grandma, did not want to return to Mexico. The district court accordingly denied Carmen's petition. Carmen appealed to the Ninth Circuit, but the Ninth Circuit affected the trial court's decision. Indeed, the Ninth Circuit agrees this was a wrongful removal by grandma, but the Hague Convention and the U.S. Legislation that enacts its enforcement here both say if you don't file your petition within a year after you know about the wrongful removal, the return will be discretionary. And here on the merits, the Ninth Circuit found no reason to disturb the exercise of the district court's discretionary decision not to order the child removed. Bob?
Enrique JP is at page 17 of your materials. We cite this dependency court case for a very limited purpose that applies in parentage cases. Albert was not the biodad of JP. In a dependency hearing, he sought presumed father status under Family Code section 7611, but he was denied. About 6 months later, at a further hearing, the court decided to reconsider its ruling and grant the status under Welfare and Institutions Code 385, which says any order in a dependency case may be modified or set aside if the judge finds that proper. The Uniform Parentage Act in the Family Code controls parentage decisions, even in a dependency case. And Mom says Family Code 7636 prohibits reconsideration. 7636 essentially says a parentage or non-parentage finding is determinative. That's a possible interpretation of that section, says the Court of Appeal, but Mom has totally ignored Family Code section 7642, which says the court has continuing jurisdiction to modify or set aside an order or judgment made under the UPA. Court of Appeal distinguishes Scott versus Superior Court that limits to a degree the court's ability to revisit the issue, noting that in that case, the request was not made in a still ongoing case like this one. So like the 2020 election for some people, it's not over as long as you're still in court. Jim.
In Nordgard versus Nordgard, we're dealing with another Hague case. Here, the parties married in California and have 2 children. Both of them are born here. The children are now 17 and 20 years of age. In 2007, however, they moved to Denmark. Wife that once in Denmark accused husband of domestic violence. But in 2010, the Danish court acquitted him of the domestic violence allegations. And to make matters worse for Mom, in 2011, they awarded Dad custody. 2 years later, in 2013, the wife orchestrated a plan to get the youngest child out of Denver and to live with the maternal grandmother in the United States. The following year, the child was located here. This is not the Nordgard's first appeal in California. A previous appeal in 2005 can be found at 244 Cal App 4th, page 76. After hearing on remand in the second trial, the trial court also found the claim of abuse to be false. At this point, given the age of the child, the issue became moot as the child was over the age of 16. But what about the attorney fees? Generally, when a matter is moot, the appeal court will dismiss the action. But here, the trial court allowed fees to father in the amount of $229,755, payable at $900 a month. Well, under Article 4 of the convention itself applies only to children under age 16. As pointed out already, the child is now 17. But the fee request was filed before the child was 16. The court thus concludes that so long as the court has issued a return order before the child is 16, it has the power to rule on the parties' fees and costs, even if that happens after the child turns 16. This case is again remanded to the trial court so that husband can comply with the notice and service requirements under CCP 1005. Of course, the new request can now ask for additional fees under this appeal. Bob?
No, actually, I think it's me.
No, I got it, D'Souza.
Okay.
D'Souza.
And in remarriage of D'Souza is found at page 20 of your materials. After the dissolution action commenced, and after he was served with the atros, husband used community money to make 3 separate purchases of Bitcoins from the Mt. Gox company. One purchase he did directly, one he did through a third party, and one he did with a partner. All were done within a 3-day period. Had he collected on all the coins, they would have totaled 1,062.21 coins, but only 613.53 were in husband's possession, and the rest were tied up in the bankruptcy of Mt. Gox. The trial court finds a breach of fiduciary duties by husband in his purchase of the coins in violation of the atros, in failing to inform wife of the Mt. Gox bankruptcy, in withholding information about the purchases in discovery, in failing to produce documents related to the coins, and in failing to file a claim in the Mt. Gox bankruptcy. He's ordered to give wife some cash and about 250 Bitcoins out of his 1/2 share of the 613 remaining. On appeal, husband says, my failure to give wife information regarding the purchases is not material because during the marriage, she was totally uninterested in the family finances. The Court of Appeal says, while that was true during the marriage, things change once a disso is filed and lawyers are brought in to give advice. Husband next says, okay, even if I failed to tell her, no loss. We spent about $100,000 to buy all the coins, and what we have left is now worth about 3.4 million. And, with recent circumstances, probably a lot more now. No dice, says the Court of Appeal. You can't offset an undisclosed bad investment with an undisclosed good investment. They have to each be treated separately. Husband's last gap is to claim that the 3 purchases were all just one unitary investment, but the trial court found otherwise, and the Court of Appeal won't reconsider the factual finding. How much better off would husband be if he just told her what he was doing? It confirms that old stock market adage, bulls make money, bears make money, pigs get slaughtered. Keith.
The next case is in re marriage of Molanka and Koda Yamplakil at page 23. Sithaj Koda Yamplakil, a citizen of India, and U.S. citizen Carolyn Molanka, married in 2011. Sithaj stayed in India until 2013, and Carolyn finished her medical residency in the United States. Once Sithaj came to the United States in 2013, Carolyn practiced medicine, but Sithaj did not work or earn income in the United States. The parties lived really, really frugally. when they did live together, even though Carolyn's income exceeded $225,000 a year. Before marriage, Carolyn had borrowed $153,000 in student loans for medical school and completed her residency. She also had borrowed, before marriage, about $120,000 from her parents, and she repaid those loans almost entirely from community property earnings, with her last payment of $60,000 made about 2 days before she went to a family law lawyer to file for divorce from Sithaj. Also during that marriage, Carolyn spent $75,000 for extensive gifts for her parents and repaid her brother for a loan from him. At trial, Sithaj claimed, look, Carolyn owes the community reimbursement for all those loan payments pursuant to Family Code Section 2641, which deals with student loans and educational costs, and for reimbursement of the non-student loans paid to Carolyn's parents, and her gifts and community funds for her family, which would be a breach of fiduciary duty under Family Code Section 1101. The trial court clearly hated this guy. The court denies Sithaj's reimbursement requests, all of them. He found, it was a she judge, found that Carolyn worked and Sithaj did not work and therefore did not contribute to the repayment of Carolyn's loans or to the cost of living, as low as it might be. The trial court also found that Carolyn had not breached her fiduciary duty under Section 1101 by repaying loans to her parents or making large gifts to her parents. It found that ordering reimbursement from Carolyn to the community, quote, would be contrary to law and unjust, unquote. Sithaj had run up $108,000 in attorney fees in fighting this case, and the court's total fee award to Sithaj is $10,000. $5,000 pendente lite, $5,000 at trial. Sithaj appealed, and the Court of Appeal reversed and remanded. The court found that 2641 mandates reimbursement of educational expenses and repayment of student loans if the community is not substantially benefited from such loans and educational expenses. There's a rebuttable presumption the community is not benefited if the contributions were made fewer than 10 years before the parties divorced, and this was a 4-year marriage. Family Code Section 2641 recites exceptions to that presumption, but none apply here. The court held that the court's discretion to find an exception to Section 2641 has to be of the same kind of exception that are expressly contained in the statute. And the court does not have an overall broad discretion to find an exception. Further, the fact that Sithaj didn't earn or contribute to the repayment is not an exception in the code. Accordingly, the court held that Carolyn has to reimburse the community for those repayments pursuant to Family Code Section 2641. The Court of Appeal also held that Carolyn's gifts and non-student loan repayments to her family breach Section 1101, the fiduciary duty. And in addition, Sithaj could require Carolyn to reimburse the community pursuant to Family Code Section 920 for those loan repayments because he made his claim for reimbursement within 3 years after Carolyn had given that money to her family in repayment of the loans. And the measly attorney fee order, it was reversed as well. Bob?
Can I interrupt? We skipped one case accidentally, DeLuca, and I know everybody has to be waiting for that case. You're looking at it, Bob.
You're right.
Okay. I talked earlier to wet your whistle a little bit about what do you do since you can't depreciate or expense out property. So marriage of DeLuca really deals with the issue. And this came up on whether to reduce the income available for spousal support should include the whole of a payment made to the obligor's separate real property that was rented out, or should it be limited only to the interest portion and not include the principal? Here, correctly, wife contends that the principal reduction acts actually to increase husband's equity in the real property. But 4320 gives the trial court broad discretion when setting spousal support, just so long as it is not arbitrary. As we saw in Blazer at 2009, 176 Cal App 4th, 1438, reasonable business expenses may include funds put aside that may be necessary to capitalize the diversification of work. Here, this court reviews several jurisdictions on whether to include or exclude the principal payments as a business expense. In the end, they accept the view of the well-known state of Wyoming. A parent's ability to pay support is directly connected to the debt reduction reasonably necessary for the production of income. The trial court, in its discretion, must look to see if it is reasonably and legitimately acts to reduce income or as a business expense. The trial court can exercise its discretion if the debt reduction is excessive, or if the asset was acquired to reduce child support, or any other circumstances indicating that the principal payments are not reasonable, unreimbursed, or legitimate. Thus, the principal payments, in addition to the interest, can be excluded from income, even if it acts to increase a party's net worth. When I was in accounting school, business school back at Berkeley, we used to refer to this as a cash flow statement, where you make the adjustment, adding in non-cash items, but deducting all cash items, whether on tax return or not. I think now, Bob.
Okay.
Moeller.
Yes. Thank you. In remarriage of Moeller is at page 25 of your materials. Husband owned the family residence before marriage, but there was no dispute that the community paid down the principal on the mortgage. And everyone agreed that using a Moore-Marsden calculation to the date of separation, the community interest would be 33.66%. But husband lived in the house for 6 years after separation, and wife contended the pay down for that period should be added to the community side of the ledger, despite being paid by his separate property. The precise theory wife argued is not set forth in the opinion, but it clearly was based on compensation to the community for the husband's use of the residence during separation. The trial court bought that argument, but was reversed on appeal. The Moore-Marsden calculation, according to the Court of Appeal, stops when the community stops putting money into the house. And if compensation for the use of the house is appropriate, that can be accomplished by a Watts charge for the community's loss of rental. The Court of Appeal notes this is a case of first impression that allows a Watts charge on a separate asset with a Moore-Marsden community interest. The charge would be calculated by determining the fair rental value, subtracting the carrying costs paid by husband, like the mortgage, taxes, insurance, and maintenance and repairs, and then applying the community percentage of 33.66% to the net rent. The matter is remanded so the trial court can do just that. Jim, back to Jim.
Yeah, back. Okay, in Safarian versus Gargassian, husband and wife sued the defendants in this case for fraud. Soon after that, they filed for divorce. And in their marital settlement agreement, they each agreed that they could individually pursue their separate claims against the defendants. 3 years later, they get their 5-figure judgment against the defendants. However, a year after that, Husband files for bankruptcy. Here it gets very interesting because the defendants in the fraud case contact the bankruptcy trustee to settle, which they did. And then the defendants then come to the state court and file for a protective order to stay all collection proceedings by the wife, contending the fraud action was community property. Wife contended that under the marital settlement agreement, her share was now separate. So the question before us becomes, does a marital settlement agreement meet the requirements of an 852 transmutation? The purpose of 852 is to set up the rules to prevent transmutation based on unreliable evidence, what we used to many years ago call pillow talk. What is important here, do the defendants in the fraud case have a right to contest the MSA under 852? In other words, does the failure to follow the rules of 852 make the transmutation void, or is it merely voidable? So under 852, the failure to comply with the transmutation requirements make it, quote, non-valid. Invalid is not the equivalent of void, it is voidable. Thus, the spouse can seek to invalidate the agreement, but not a stranger to it. Even so, a quick practice pointer has to be tighten up your marital settlement agreements so it includes the 852 language, and you won't have a problem here. Keith?
The next case is In re Brace at page 28. A husband, but not the wife, filed for Chapter 7 bankruptcy. The husband and wife owned two houses, one bought in 1977 and the other around 1985, using community property to buy them. The title for both houses was husband and wife as joint tenants. The Chapter 7 bankruptcy trustee claimed that despite the joint tenancy title, the houses were community property. The husband and wife disagreed. If the houses were community property, 100% of the houses go into the bankruptcy estate. If the houses were the separate property of each spouse, only the bankrupt husband's 50% of the house would go into the bankruptcy estate, and the wife would retain her 50% share of the house. The Ninth Circuit asked the California Supreme Court to declare what California law actually said. The California Supreme Court first held that Evidence Code 662, which says that the owner of legal title to a property is presumed to be the owner of the full beneficial title, does not apply to interfere with the community property presumptions of Family Code Section 760, which says all property acquired by a married person during the marriage while domiciled in California is community property. The court rejected the argument that simply taking title to the property in joint tenancy form results in the form of the deed being an express declaration by the husband and wife that transmutes community property into the separate property of the parties held as joint tenants. Such a deed does not satisfy Family Code Section 852 requirements for transmuting property. But Section 852 didn't become the law until 1985. The court held that the character of property held by a married couple in joint tenancy depends on when did they acquire the property. For property acquired prior to 1975, when women were given joint management and control of community property, property acquired in joint tenancy form with community property funds was indeed joint tenancy property of the husband and wife, not community property. For joint tenancy property acquired between 1975 and 1984, the court held that the joint tenancy property is presumptively community property, but the presumption can be rebutted with evidence, including oral testimony, that's the pillow talk, that the parties agreed the property would really be the separate property of husband and wife, each owning half the property. So there's still room for imaginative evidence to come in these cases. For joint tenancy property acquired on or after January 1, 1985, notwithstanding the joint tenancy title, the property is indisputably community property and the trustee gets it all. And Jim has just explained Section 852. We think we all come across 852 frequently. It requires a writing to transmute property from separate to community and vice versa. And just having a deed that says husband and wife as joint tenants doesn't satisfy Section 852. The court also held that Family Code Section 2581, which creates a presumption that property held by a married couple in any joint form is presumed to be community property at the time of divorce, doesn't imply a different result in other situations, such as bankruptcy. The bottom line here, timing is everything. Bob?
Thank you. Trank versus Soheili is at page 29 of your materials. This civil case involved the enforcement of a deed of trust. The reason it's important to us is one of the bases on which the Court of Appeal reversed the trial court's enforcement of the deed. There are a lot of interesting facts in the case, since the note secured by the trustee was from an attorney to settle a malpractice claim brought by his former client. But most of the facts aren't really important to us today. What is important is that the property was co-owned by husband and wife, and only husband signed the trust deed. No one disputed that per Family Code Section 1102A, both spouses must sign a document encumbering community real property. But this house was held in joint tenancy, which is a form of separate property ownership. So plaintiff says Family Code Section 760 doesn't apply. In denying that claim, the Court of Appeal notes that Family Code 760 establishes the presumption that property acquired during the marriage is community property. They cite the Brace case that we just heard about that says that the presumption also applies outside of a disso case, that it trumps the title presumption of Evidence Code 662, and the mere titling of a property as joint tenancy isn't sufficient to show an intent to transmute community property to separate property. Appellants argue that the Brace case mentions the Family Code 760 presumption applies when the parties use community funds to acquire the property, and that the plaintiffs in this case didn't prove that they used community money to buy it. But that language in Brace only described the facts of that case. No proof of the source of funds is required for the 760 presumption to apply, only proof that the acquisition occurred during the marriage. Rather, it's the reverse. Proof of the separate funds used would be a part of the evidence that might be used to rebut the presumption. Jim.
Okay, the next case, the parties in Wozniak were married for 16 years. As far as I can tell from this case, neither of the Wozniaks in this case owned any stock in Apple. What was owned by them was some real property in La Mesa. There is no dispute that originally it was wife's separate property. At some point during the marriage, it was converted to joint tenancy in order to get refinancing. We've heard this story so many times in the past. But here's the twist. Husband executed an interspousal transfer deed to transfer title back to wife. However, she says, no, I really don't want that. However, again, at trial, the document shows up and husband claims that wife had rejected it. Wife contended otherwise. The trial court accepts husband's testimony and found that all of the property was 2581 community property. As far as I can tell, wife had no backup plan for a 2640 reimbursement. Section 852 provides for a transmutation. It must be in writing with an express declaration that it is made, joined in, consented to, or accepted by the spouse whose interest is adversely affected. Of course, the adversely affected spouse here is the husband, not the wife. Thus, no 852. So then the court looks at section 850. A transmutation is by agreement or by way of transfer. Under 850, agreement and transfer must have different meanings. Otherwise, it would just be surplusage. Here, there is no agreement. The transfer must be made and accepted by the party. It wasn't accepted. Bottom line, the law does not force one to accept the real property transfer against his or her will. A final interesting point, years after rejecting the deed, apparently it was never destroyed and wife recorded it. What was missing was that the husband would have to re-deliver the deed to her in order for her to have recorded it. Keith?
The next case is in re marriage of Nevi and Clemonas. It's at page 32 of your materials. This case contains a long, boring recitation of the financial evidence that helps none of us. It has only 1.5 lessons for us. The big lesson deals with Moore Marsden and whether the community is entitled to also be reimbursed for property taxes and mortgage interest it paid on the separate property and separate property mortgage. Spoiler alert, the answer is no. Here are the facts. Before John and Martha married in 2003, Martha bought a lot on Lake Tahoe and built a cabin at a total cost of $289,000 and paid for most of it with a mortgage. Tahoe was worth $525,000 at the date of marriage. Martha's mortgage and property taxes were paid with community property during the marriage. The community also paid for $7,000 worth of improvements. At the Disso trial, the court found the value of Tahoe to be $735,000. The unpaid principal balance remaining on the mortgage was $170,000, and the community had paid down about $100,000 of principal on that mortgage. The trial court, relying on John's forensic accountant, determined that the community's interest in Tahoe, pursuant to Moore Marsden, was approximately $176,000. However, John's expert actually calculated the Moore Marsden interest at only $73,000 and then added a claim for reimbursement to the community of $103,000 for the mortgage interest and property taxes the community had paid on Martha's Tahoe property, net of any tax savings to the community realized from the mortgage interest deduction. Martha appeals and the Court of Appeal reversed. The rule of Moore Marsden is that mortgage interest and property taxes are not included in any Moore Marsden calculation of the community's interest in one party's separate property. Cases that John cited to support his claim were distinguishable and found not to be compatible with the Moore Marsden calculation. The trial court erred in crediting the community with the right to be reimbursed by Martha for the mortgage interest and property taxes. So what's the half lesson in the case? I'm going to tell you what it is, but you can't cite the case to prove it. The Court of Appeal non-published a part of it that made it really, really clear it's just flat out reversible error for a trial court to rely on Dissomaster or the like in setting permanent spousal support. The trial court needs to do a Family Code Section 4320 analysis in setting support. Here, the evidence was very clear that the court used Dissomaster to set permanent spousal support. That's reversible error. Know the rule, don't cite this case for it, but also know that parties can use Dissomaster in arriving at their own settlement of the issue of spousal support. It's just the court that can't use it at trial. Bob?
In remarriage of Guterres is found at page 33 of your materials. After her husband loses big in the trial court, he raises 4 issues on appeal. First, he says the trial court was wrong to deduct the amount of the HELOC from the value of the house that was awarded to wife. Wife testified she owed the money, but husband brought in a mortgage research officer from the bank who said the loan was written off, and he also brought in a tax preparer who reviewed documents that he testified showed the write-off. But wife showed the canceled checks accepted by the bank after the supposed write-off, and she testified that she had renegotiated the loan with the bank. The trial judge believed her, and his decision was supported by substantial evidence. End of story. The Court of Appeal won't reweigh the ruling on the facts. Husband had a strong case, but the trial court found otherwise, and there was evidence to support it. Second issue was the imposition of sanctions for husband's breach of fiduciary duty by not disclosing another property that the parties owned on his PDD and FDD. He says it's not a problem. She always knew about that property, so there's no concealment. And he cites some civil fraud cases in support. Court of Appeal says those do not apply because the point of our statute is not to address and compensate a civil wrong. Rather, it is to create incentives for divorcing parties to be candid with each other. That is, to spur good conduct looking forward rather than punishing bad conduct looking backwards. The next 2 issues concern a third property. The court had ordered that property sold and the proceeds to be split and made that order in 2008. Husband finally did sell it in 2011, but he didn't tell wife that he sold it, and he didn't give her share until the time of trial in 2015. He said the order was unclear and it didn't tell him to act to give her the money immediately. He loses, of course. As the court notes, there's an implied requirement in all orders to act in good faith, and this was not good faith. He owes the 1/2 plus interest from the date of sale. Incidentally, husband had no documentation about the sale, and the amount that he said he received from the sale was about $100,000 less than what the parties paid. The trial judge was very skeptical about that number, but he had no other evidence regarding the price, so he accepted the fishy amount. And maybe that influenced the trial judge on the 4th issue. He denied husband's request for reimbursement of property taxes paid on the property. While husband lacked documentary evidence of the payment, the trial judge assumed that he paid it, but denied Epstein reimbursements on equitable grounds. The Court of Appeal notes that there was no challenge on appeal to the court's equitable authority in an Epstein reimbursement, and thus there was no abuse of discretion. Does the trial judge really have that equitable power in Epstein as opposed to something like Watts? Well, we'll have to wait for another case to find out. But the one message that we've heard before tonight is that bad people often do less well on any close calls. Jim.
Okay, our next case is George versus Shams-Shirazi. And here we're dealing with 271 sanctions arising out of the party's child custody case. Keeping the party straight is a little difficult, as George is actually the last name of the mother, and Shams-Shirazi is the appellant father. Well, in January 2017, the court awarded mother sole physical and legal custody of the minor child. 6 months later, in June, father files a 473 motion and sought a different timeshare. Both of those requests were denied. Undeterred, father files a new request in September, 3 months later. At each hearing, mother's request for sanctions was denied. But in March 21st of 2018, mother again seeks 271 sanctions. This time she prevails to the tune of $10,000. Father sought an ex parte reconsideration, which cost him another $3,000. On appeal, father contends the sanction motion filed 226 days after the trial court order was untimely under Rule 3.1702 subdivision B. 3.1702B provides in part that a request for attorney fees must be served within the time for filing a notice of appeal under either 8.104 or 8.108. These two sections themselves provide that 60 days within the notice of entry of judgment, or 180 days if the entry of judgment happens with no notice. Well, 226 days is past either one of those time limits, but father loses, as 3.1702 applies to post-judgment motions. Post-judgments requires a statutory fee, which are based on equitable grounds. The principle of laches here would then apply if the filing unfairly prejudiced father. Remember, the delay will not alone constitute laches. So father comes up with two bases to contend that he has been prejudiced. First, his current wife was on medical leave due to the birth of a new child. Secondly, just as we've seen in our courts downtown in LA, a turnover of judges caused the latest sanction order to be heard by a new judge. Well, neither of these positions gained sanction. The sanctions order previously made by the trial court is affirmed.
The next case, I'm going to take a case out of order here. I'm going to talk about Rockefeller Technologies Investments Asia 7 versus Changzhou Sinotype Technology Company, Ltd. It's at page 40 of your materials. Right, the parties here are sophisticated business entities. They enter into a contract where they agree to submit to the jurisdiction of California courts and to resolve disputes between them through California arbitration. They also agree to provide notice and, quote, service of process, unquote, to each other through Federal Express, now FedEx, or some similar courier. The narrow question this case addresses is whether the Convention on the Service Abroad of Judicial and Extrajudicial Documents in Civil or Commercial Matters, also known as the Hague Service Convention, preempts such notice provisions if the convention provides for a different method of service. Consistent with the United States Supreme Court authority, the California Supreme Court concluded that the convention applies only when the law of the forum state requires formal service of process to be sent abroad. Well, guess what the forum state is? It's not China, it's California. The court further concluded that because the parties' agreement constituted a waiver of formal service of process under California law in favor of an alternative form of notification, the convention does not apply. The plaintiff had entered into a contract where if there were disputes, they were going to arbitrate it in California, and that would be binding arbitration. And as I said, they agreed to FedEx notice and service of process. So here there is a dispute. The plaintiff uses FedEx to notify the defendant. Defendant doesn't appear. The GM's arbitrator awards the plaintiff $414 million. The defendant was notified by the arbitrator by email and FedEx. So the petitioner petitions the Los Angeles Superior Court to confirm the arbitration award and transmits the petition and summons to the defendant through FedEx and email. The defendant now does appear, specially, moves to quash and set aside any default judgment for insufficiency of service of process. The defendant argued that the plaintiff's failure to comply with the Hague Service Convention rendered the judgment confirming the arbitration void. California Supreme Court said, nope, that while China has objected to Article 10 of the convention that otherwise allows service by postal channels, that isn't what governs. What governs is what is the law of the forum state, which is California requiring for sending a document abroad to effect service. FedEx is good enough. So, because the parties agreed to FedEx, that was going to be the end of it. Accordingly, the Hague Convention doesn't apply in this case. There's an implication for family law cases. If you've got a family law case with parties who are outside of the United States, assuming you can get the foreign-based party to cooperate, this decision would appear to allow a default to be based on an agreement between the parties to sign and return a notice and acknowledgement of receipt form, rather than having to effect the costly and time-consuming service of a summons and complaint that will comply with the Hague Convention. Presumably, your default will include a stipulated judgment between the parties. It's not clear whether this case will let parties effect service of a family law summons and complaint by mail rather than compliance with the convention if the foreign-based party intends to litigate the family law case. But it might be possible. So this is actually going to be useful for family law practitioners. Thank you.
We've hit that magic hour, Ron and Carrie.
That's correct.
Time went fast.
All right. Well, thank you, Your Honors, for your presentation this evening. To all attendees, please do make sure to sign up for the second part of tonight's program, the thrilling conclusion, Family Law Annual Case Update Part 2, which will take place 1 week from tonight, Wednesday, February 3rd at 5 p.m.
Thank you to our panelists. Thank you to our attendees. Congratulations on finishing the first half of the 30th anniversary.
Thank you.
Thanks.